Hello everybody, and thank you for joining me today on this episode of Activist Lawyer, recorded in our podcast studio in Newry. Today I am delighted to be joined by Professor Donncha O'Connell. Hello Professor, thank you for joining me today.
Hi Sarah.
So just before we get into your work and have a chat, I am just going to introduce you to our listeners. So Professor Donncha O'Connell is an established Professor of Law in the School of Law, University of Galway, where he currently teaches advocacy, activism and public interest law, European human rights law, policing and administrative law. He has served terms as Dean of the Law Faculty and Head of the School of Law. Professor O'Connell has served on a number of governmental bodies, most recently the Independent Review Group to examine the Offences Against the State Acts, which reported in 2023 and in which he co-authored a minority report. He has also served 2 terms as a Commissioner of the Law Reform Commission from 2012 to 2020, and he was a member of the Commission on the Future of Policing in Ireland from 2017 to 2018. He served as a member of the Legal Aid Board as well. Professor O'Connell has also served on the boards of a number of non-governmental organisations, including Interrights, FLAC and Amnesty International Ireland. From 1999 to 2002, while on leave of absence from his academic post in Galway, he was the first full-time director of the Irish Council for Civil Liberties. He's also been a board member of the internationally acclaimed Druid Theatre Company based in Galway, which I'm familiar with. Thank you so much again for joining us. I will say to our listeners that this is our second guest on from what's now known as the University of Galway. In my day it was NUIG, going back many, many years. And I fond memories of my constitutional law lectures, which were of course delivered by yourself.
Yeah, I have vague memories of your constitutional law lectures. It's so long ago at this stage. And it was UCG in my day, and then NUIG, and now University of Galway. So it's lots of names.
It's hard to keep up, but you're still there anyway. And of course, a fantastic outline there of the work that you've done both within the college and outside of it. And we know things change ever so quickly in Ireland. But just before we get into, I suppose, the themes that we'd like to cover today, can you just, I suppose, take listeners back to how you got into law? What made you, I suppose, decide to do the academic side of law?
Yeah, I mean, nobody in my family was a lawyer. Like on my mother's and father's side, everyone was either a pharmacist, a doctor, or a teacher. I mean, they were the chosen careers. So I suppose I ended up becoming a teacher. Really, choosing law was maybe, a sad act of rebellion. I do remember my parents were really keen that I would do pharmacy, and if I didn't do pharmacy, that I would do veterinary because I liked animals. And but I wasn't really. I wasn't drawn towards that at all, and so I liked English and Irish and French and debating and things like that. So in history, I still love history. So I suppose it was kind of a strange one, but I was drawn towards that. I had a very shallow reason as well for being interested in law. I loved Rumpole on TV and Matlock, for the American version of it. So I had, all the usual shallow reasons that students choose law. And then when I did do it, I actually found it quite interesting. And in Galway, you did law through art. So you did it as part of an art program with something else. I did sociology and politics, which, I was actually better at than law, and I was probably more interested in. But, we were the kids of the 1980s drawn towards professional careers, and I did the bar with the view to practicing at the bar. And becoming an academic was a complete accident. I was looking for a reference from the then head of law, Professor Liam O'Malley, and because I was getting part-time work as a teacher in Dublin when I was going to Devil with the barrister, Mel Crystal actually was his name, and I had all that arranged, and then somebody left the law school in Galway at short notice, and they needed somebody for a year. So I ended up doing that. But Liam knew I was looking for part-time work and postponing the deadline. And I liked it. And then after that year, there were a number of permanent jobs advertised in the law faculty, as it was then called in Galway. And I applied got one of them, and thought I would do that for a while. I didn't really, I didn't really have a plan. I mean, I was only 25 at the time, and after a period of time, then I was entitled to sabbatical. So I took sabbatical leave, during which time I applied for the job of director of ICCL. This was the first time that they had a full-time paid director, and I was at that stage I was 31, which was actually frighteningly young to be the director of a non-governmental organisation. I didn't think that at the time. Confidence is a different thing when you're 31. And so I got that job, which I did for 3 years. I got leave of absence from the university. I didn't actually leave my post, even though, to be honest, I didn't intend to go back. And then, I changed my mind and went back. And, over a period of time, then took on other roles at the university and was promoted and things like that. So it was never a plan. I never set out to be an academic. And I think ultimately, what drew me towards it was I liked teaching. I see a huge value in that and the context that you have with people who will go on to do different things in their careers, some of which are of huge value, but also there's great freedom in being an academic. There's freedom to do things that you wouldn't have if you were practicing. It's very, very difficult, I think, for practitioners to engage to the degree that academics can. Not all academics choose to, in activism of various kinds and in kind of pursuing an ideal of justice that means something to you, whether you're right or wrong. And I found that academia in Galway was particularly hospitable for that, for those kinds of pursuits, and that was, that has been a very positive experience, all told. But definitely it wasn't a plan, and I think there's something in that. And I often say this to students myself: you have to plan, but you have to plan flexibly. You cannot, you simply cannot write the course of your life and follow that literally. I mean, some people say they do that, or some people, laugh when you say you shouldn't. But I really think that, planning is something not to be done to excess, and to be done in a way that leaves open options, throughout your life, bearing in mind that you will change. You're going to change in terms of your interests and your plans and your desires. So I think that's a long-winded way of saying how I accidentally became academic. Yeah.
Excellent. Yeah, I suppose law in particular, opens so many opportunities. So it's really important to have that level of flexibility. And just in terms of your teaching and your work, recently I came across the Advocacy, Activism and Public Interest Law module that's being taught. I think it was shared by students and on LinkedIn as well. And it really drew my attention to, it seems, I'm not sure how long the course has been around, but I was thinking, wow, what an opportunity. So can you tell me more maybe about that course and, what has student feedback been like?
Yeah, in 2009, 2010, I had a sabbatical year, and I spent it at the Centre for the Study of Human Rights at the LSE in London. And during that year, I did a course, an evening course. It was a certificate course organised by the late Jonathan Cooper, who sadly died in the recent times. He was a wonderful person, and he organised a course on international human rights law practice. And I kind of thought this would be interesting to do as somebody who had taught European human rights and was interested broadly in human rights. It was full of people from NGOs, government bodies and things like that. And that got me thinking about the need. We had a number of LLM options in Galway, and I used to teach a course called Processes of Law Reform, which was an interesting, piece related to the idea of public interest law, but only part of that picture. And, so I continued that course, but I thought through work I had done with the Public Interest Law Alliance, and very heavily influenced by the writing of people like Jerry White, Sandra Fredman, and others elsewhere, that there was something to be done on public interest law more generally, not just law reform, which is an aspect of public interest law. And on the area of advocacy and activism, which of course I had experiential insights on through my work in the ICCL and for a number of other NGOs. So I crafted a course, a master's course, 1 semester long, to be offered to students on the various programs in Galway on advocacy, activism and public interest law, which I think would appeal to students who, might be considering a professional path, might be considering an academic path, but were interested broadly in the idea of, law in the public interest as opposed to other manifestations of law or whatever, and might be interested in the political dimension of lawyering, unapologetically interested in the political dimension of lawyering. And there was a good degree of interest in it. I mean, it's been taught every year, bar one. There was 1 year where it wasn't taught, but we had a drop in LLM numbers in that particular year. And now in more recent times, students from the Human Rights LLM program have gravitated towards it, which is wonderful because it means that the profile of the class is now really international. And this year, the largest class, I had 20, which was a very large number. We had students from Ethiopia, Liberia, the US, Canada, the Netherlands, Ireland, of course, and India and China and other countries that I'm probably forgetting. So it really, and some of them came with experience of practice in public interest law, or practice on the state side in dealing with public interest law. So it was really, really interesting. And the course, I mean, I wouldn't be so bold as to say it's a clinical legal education course because it doesn't have, it wouldn't have enough practitioner content in it, although I bring people in from outside to do that. But the idea is to enable master's students to see themselves as public interest lawyers, or as lawyers who operate within that framework of reference, whether through human rights or other areas, and to be able to understand what advocacy is and what activists do and the regulatory framework within which activism is conducted, so that they have, tools to be public interest lawyers after completion of the master's course. And my sense is that students who choose it are, have a very strong motivation towards that type of career. And I find teaching it very enriching. I mean, it's different than teaching for courses. And teaching master's level is always different than teaching other courses, but it's a very enriching process, and it's very interesting to see what some of them go on to do afterwards. And this year, we brought back a student who did the module only, I think, 2 or 3 years ago. He did it during COVID, and he gave a wonderful guest seminar to the students on climate litigation, which he's now doing PhD on in UCD. It was a really brilliant seminar, and I think the students found that immensely beneficial, not just in terms of its substantive content, but they could also see themselves doing something like what he did immediately after their master's program, and I think that's a really great thing.
It is. It's such a valuable opportunity. I mean, things have really moved on since I've been at college, but I find like one of the questions we'd even get asked here, and students would send it in, how do I become an activist lawyer? And for me, that just was not a term. It did not exist. So it's really fantastic that Galway, and I suppose other third level institutes as well, offer similar courses and have that hands-on experience too. You mentioned there as well about working in, you have that more of a freedom, I guess, than practitioners would, as a result of working within the academic side of law. And you yourself, you've written extensively on policing matters in Ireland being one topic, and I guess that's a very topical issue at the moment. Of course, you lecture on the subject, and you were a member of the Commission on the Future of Policing in Ireland. I suppose the question is Ireland facing a crisis when it comes to policing and law and order? And I'm saying this in a general sense, but more so in the back of maybe what's happened 2 to 3 weeks ago. We had Solicitor Gary Daly on previously talking about the riots in Dublin, so listeners might be familiar with that. But I suppose it has really shone a light on policing in general And I'm just interested in hearing, your take on it in view of the riots. How much force can or should the Gardaí be using following the Dublin riots?
I mean, the language of crisis is always used in respect of policing services everywhere. They're always in the eye of some controversy, and they're always dealing with crisis type situations. I mean, you could argue that crisis management is an aspect of policing. So the kind of controversy that ensued after the riots in Dublin 2 weeks ago is, in a sense, I would say, the normal level of controversy that policing services cope with.
Sure.
However, in 2017, when the Commission on the Future of Policing, of which I was a member, was established, the kind of crisis which the Irish policing service found itself in was an existential crisis. It related to, endemic and chronic scandals in areas of policing. It related to, deep dysfunction at the leadership and governance level, and indeed at the political level in policing in Ireland. And for that reason, the Commission was established under the chairmanship of Cathy O'Toole, who had been on the Patent Commission in Northern Ireland, in order to address in a holistic way the problems of policing in the South and setting out a blueprint for the future of policing. So, that to me was the real crisis. The kind of things that are happening now, industrial relations problems with regard to representative bodies, arguments about rosters, terms and conditions, evidence of low morale, which I think is real, but you will always get that in the context of significant change, and questions about the ability to withstand threats from the far right that have been underestimated, frankly, because of a disproportionate focus on historical security threats. Those are, real serious issues, but I think they're, in a sense, the normal issues of crisis and controversy with which policing services contend, and our ability to navigate those, to have the argument and the public discussion about what happened, to achieve some resolution by, interacting with bodies like the policing authority and whatever. I think those are all actually good signs, not necessarily negative signs. It remains to be seen, by the way, whether all of those mechanisms work in the context of that most recent problem with the riot. But I don't think that it's as big a deal as the problems were in 2017 when the Commission on the Future of Policing were established. And I think we lose sight of that very easily. I think the press, in particular, in the South is very, very driven by current controversies and what you might, consider to be in a way more kind of melodramatic happening. They forget actually how bad things were in 2017 and how much has been done, albeit at a slower pace because of COVID, to address that, and how much is still to be achieved in terms of embedding community policing, like real policing with communities, not just the phrase community policing, going forward. And I think that should really be the focus of what happened in the past couple of weeks in Dublin.
Awful. And then I suppose on a broader level, and it's something that we've covered on at least 2 occasions, and I guess it feeds into it, the criminal justice structure in Ireland in general. And I suppose what I'm talking about is reform around the matter broadly when it comes to per legal aid funding when it comes to crime. Do you see that, I suppose, reform, and whoever's responsible for it, whether it's the Minister for Justice, is in fact needed on an overall scale to improve the situation around criminal justice in general, whether that be policing?
I mean, that's a really good point. Conor Brady, the former editor at the Irish Times and former member of GSOC, and a recognised historian of policing in Ireland, he's written very well about a more kind of holistic approach to the criminal justice system in the South, for the Currency, which is an online journal, and he wrote a very worthwhile piece recently on that. Joining up the dots of crises in various parts of the system, and making some extremely valuable points, and points that are borne out by a lifetime of experience in this area, and a deep interest in the subject matter. And I would recommend that piece to anyone. I mean, I think it's a really, really good piece. I think in order to kind of tackle those issues at a holistic level, the Department of Justice, which is the lead department, although there is a multi-agency dimension to a lot of this, and that has to be acknowledged. Yeah. And in fact, the Commission on the Future of Policing was really clear on the multi-agency nature of problems, and that informed our recommendation on local community policing partnerships, which is contained in the legislation to implement our recommendations. But the Department of Justice is unavoidably the lead department in this respect. And one of the concerns that I have in that regard is that even with the best will in the world, that department defaults to quite conservative thinking when it comes to reform issues. I know this from my time on the Law Reform Commission, but I also know it in other contexts. Mm-hmm. And that is a problem, that you simply cannot luxuriate in the certainties of the past. You must have processes that are genuinely open, not token consultative processes to say that you consulted, but that actually listen to what others from outside the department have to say, and others with genuine expertise based on comparative analysis, which we can't have enough of, have to say. And I think that is still a work in progress in the Department of Justice. There are some excellent people in that department, doing their level best to, make policy change that is progressive and that is workable and practical. But I think overall that department is still in its setting conservative and not sufficiently open to the kind of thinking that's required to modernise policing and all sorts of other areas as well, including the area of national security. And I think that requires a huge amount of more work and real political leadership. There is a degree to which that can be blamed on the political leadership or the lack of political leadership, but there's also, I think, a comfortable coexistence between the embedded thinking in that department and what passes through that department as political leadership from time to time. And I think one of the ways of dealing with that, and I've spoken about this previously, is to engage with stakeholders, whether academic or policy experts or others, on the basis that you don't have to agree on everything, but on the basis that you're actually listening. Sure. And not on the basis that you're going through the motions of consultation, which your mind is already made up. Mm-hmm.
So it remains to be seen, I guess, and lots of work to do around those areas in general. And I know that you served as a commissioner on the Law Reform Commission, as mentioned, but also on the independent review group to examine the offences against the state acts. And we mentioned already that you co-authored the minority report on the back of that review. The Acts itself, and I went down a little bit of a rabbit hole when I was looking over this, they were really a bit of a tumultuous history in Ireland in terms of, they seem to have the Acts and the various amendments to the Acts responsive to, I suppose, outbreaks of violence as well, even in the north, have impacted some of the changes. So first, before we get into your work, could you maybe give us a little outline of the acts that were being reviewed, and maybe as well why so many human rights organisations and civil liberties groups in Ireland had lobbied for reform and I think welcomed the changes overall?
Well, myself and Dr. Alan Green from Birmingham Law School were the two authors of Minority Report, and our view would be that the Offences Against the State Act is an example of permanent emergency legislation. The idea of permanent emergency legislation, which is of course permitted on a particular reading by the Irish Constitution, But our view is that that is a bad idea, and that in legislating for issues, like undoubtedly serious issues like terrorism and organised crime, that it shouldn't be done using that model of permanent emergency legislation. I suppose the informing principle of our view is that the Constitution enshrines trial by jury as the gold standard for serious criminal matters, and that the continued existence and increased use of the Special Criminal Court goes against that constitutional ideal, even though that has been approved on many occasions by the Irish Supreme Court. Our view was that that was done on the basis of the application of the deference principle to the executive and to the parliament. In constitutional law, we understand that completely, but that in reviewing something like this, we shouldn't apply, in a sense, a double deference and take the view that because the Supreme Court says it's okay, it's okay. Our view was that it doesn't have to be like that, and that it is possible within the framework of the Irish Constitution to take the right to trial by jury more seriously and to protect it in a more meaningful manner, and not to, in a sense, continue with what has been there, very actively since the early 70s, but actually since the 1940s. And there are whole sorts of other related issues to do with opinion evidence, to do with prescription and other things that we commented on as well. So it was a fairly fundamental difference of opinion with our colleagues in the majority. And however, we did agree unanimously that the Offences Against the State Act should be repealed. Okay. And we didn't agree on what should replace them. And the Hedderman Review, which happened in 2000, 2001, it also recommended repeal of the Offences Against the State Act. So, there is a real job of work to be done here, post this second review. And, the Department of Justice response was actually to go back to some of the people that we engaged with, the DCP, An Garda Síochána, the Irish Human Rights and Equality Commission and others, which completely, makes no sense. We engaged, in great detail with these bodies and presented our differing views. And, to then decide, well, we'll go back and we'll ask them ourselves, is not an adequate response to a review such as this. And that, frankly, troubles me, having spent 2 years on it and having worked very diligently in preparing with my colleague Alan a minority report.
Mm-hmm. And when do we expect to see any progress around this? Is it just kind of lying low for a while?
That question should be directed to the Department of Justice. I'm certainly not holding my breath. But if it's of interest maybe to your listeners, I am organising with Alan Green a conference on the 16th of February in the University of Galway on the theme of replacing the Offences Against the State Act and the real challenges of trial by jury for terrorism and organised crime. And we will have speakers at that from the US, Australia, the United Kingdom, and Ireland itself. And we're bringing together a collection of experts and some practitioners to really explore in more detail than the review group did, in fact, the options that the state has in replacing the Offences Against the State Act or the Offences Against the State Act. And I would strongly encourage people who are interested in that, to attend the conference or to engage with the conference in some way. It's a genuine effort to, inform the debate and add more expert insight to the deliberations. I mean, the political system may be somewhat closed to that and somewhat lacking in interest, but that doesn't mean that you can't continue to offer some ideas. And we're doing that, as I say, on the 15th of February in Galway. There will be Eventbrite registration notices distributed in the coming week.
Very good.
And so far we have an excellent lineup of speakers. So I'm hoping that it will do something to enrich whatever deliberation is taking place, or whatever deliberation will take place in coming time. I mean, in Ireland, it's generally, there's a generally kind of a tumultuous 24 hours of interest in this, and you have to renew certain provisions of the 1998 Offences Against State Amendment Act and other pieces of legislation. And it has really centred around Sinn Féin's pivot away from its lack of support for the Special Criminal Court towards its new position, which is not entirely clear. And the press faithfully records that as, a day-long drama-rama that's really about nothing. And what we would invite people to do is to actually consider the issues, the important issues that are involved here, and engage in a more serious and less childish way, frankly, with this debate. And also that entails, the likes of Sinn Féin who are important in this, engaging seriously as well and coming up with a coherent position, not merely a position.
Sure.
And that, requires of all of us, I think, a degree of serious engagement, which has been desperately lacking to date. So, for better or for worse, and perhaps in pursuit of futility, we will keep going, talking on this issue.
Yeah, so
this
important.
Passionate way. Yeah. It's designed to actually achieve some good in the area of public discourse on the right to trial by jury and broadly due process.
And a lot of your work anyway, and your publications necessarily deal with the interaction between, I suppose, government and the law, politics and the law, and perhaps more so even in a constitutional setting. I read one of your pieces that you wrote just about the role of the Attorney General and what lies in the public interest. But just in a general point, how adaptable, I suppose, is the Irish Constitution? I mean, Ireland have there been 32 amendments, I think, since 1937, maybe more. I'm just wondering on the flexibility of it, and are the Irish public, the Irish people, amenable to see change? It's something that obviously is very unique to Ireland when we look at what the UK have. So I'm just interested in your broad view on that.
Yeah, it's a really big question. I mean, the biggest problem with the Irish Constitution as it's interpreted by the Irish judiciary is its resistance and antipathy to socioeconomic rights. But I've long held the view that socioeconomic rights would be very popular with the public.
Yeah.
And I don't buy into the argument made by some that if it means higher taxes, it won't be. I actually don't buy that argument at all. And I think that the public are actually quite distributed in their mindset and get the need for some constitutional underpinnings. I'm not necessarily saying rigid ones, but some constitutional underpinnings for distributive justice and socioeconomic rights in that broad sense. But we've closed off that possibility, certainly in the 90s with a very, strong position taken by the Supreme Court in reaction to the use of mandatory orders by some High Court judges in areas that entrenched upon socioeconomic rights and socioeconomic justice. I think that's hugely regrettable, and I think it's something that in any reconstitutionalising of Ireland will almost certainly be revisited. I mean, it has to be if our international obligations are to mean anything. And there are good examples of where we could go with that, say, the South African system and other places. So that to me is a big concern. But what I find kind of interesting, and it's bubbling up right now in relation to an amendment that's going to be put to the people in the referendum on the 8th of March in 2024, is that the government seems very much swayed by the advice of the Office of the Attorney General and not by the Citizens' Assembly, which I think does actually give a good representation of where the public are at in its decision not to make a strong mention in the Constitution to the value of care in the family in the context of deleting the reference to women in the home, which is, of course, a welcome thing, and redefining certain family rights under the Constitution, however inelegantly. And I think that's going to be a very interesting moment in our constitutional change history, because there will be a temptation on the part, particularly of civil society groups, to support the package of amendments being put forward. But they need to be very, very careful about that, because in putting the formula of striving to achieve or striving to support care in the home, that's really very little more than, as Conor O'Mahony from UCC has pointed out, you're replacing essentially sexist language with gender-neutral language, but it's still a thought.
Yeah.
And it's not a recognition in any meaningful way of rights, of course, because they're such economic. That is classic thinking of the department, or sorry, of the Office of the Attorney General. It's classic thinking of the government system and indeed of the Irish judiciary. Not all of them, but many of them. And I think that's regrettable. I think I think it's a pathetic amendment, quite frankly, and I hope it's not passed. I certainly hope it's not supported by important civil society groups, particularly the National Women's Council. And it will be very interesting to see how that, is debated and ultimately received. It may end up like the children's rights referendum, being passed in a kind of an apathetic way, but it may not. It may become a moment where people will actually say, no, like, this is not what we want by way of constitutional change. It's not what we want by way of values in the Constitution. We're not convinced by the argument of a sudden lurch towards judicial activism, where the Supreme Court will all become mad redistributors of public goods. I mean, I don't think anyone really takes that very seriously, and I think it would be a good moment for those of us who would prefer a different emphasis in constitutional law to, in fact, use the opportunity of a referendum to reject what is, quite frankly, a patronising and pointless change.
Well, that's it. March, is that the date for that referendum?
March the 8th, yeah. It's International Women's Day, which again is,
correct,
kind of your kind of thinking, the shallow thinking actually that goes on in relation to these things. It's actually a very overdue amendment, particularly on the question of women in the home. I mean, it's ridiculous. It's ridiculous that we're only dealing with that now. It had to be discussed as far away as 1996. I probably taught you about that when you were in Galway, because it was in the Constitution that you could handle the court opposed at the time of the enactment of the Constitution. So, the women have been made to wait until now, but what have they been given?
Yeah.
Like, it's not just women, of course, it's others as well, who have a really, meaningless, virtue signalling pat on the head in the Constitution, but not one that I think is worth supporting.
Yeah. Well, we await the outcome of that. It'll be an interesting time leading up to March. Just in relation to your work, finally, on the European human rights law that you lecture on and you've published quite widely on as well. I'm guessing you have keep an eye on what's happening in the UK and, of course, how that impacts the North and the island here as a whole, with I suppose we can call it an attempt to kind of diminish human rights, replace it with a very Tory version of human rights with their own act. I know some of the Conservatives' plans have already been thrown out, but no doubt it gave a lot of kind of food for thought in terms of the convention, the European Convention on Human Rights, our reliance on it, and more particularly in terms of Northern Ireland, its impact on the Good Friday Agreement and whether getting rid of it would have any, would really threaten the Good Friday Agreement, and also the kind of pressing need here and the voice for a Bill of Rights in the North. What is your take on all of that?
Yeah, I mean, at least the Good Friday Agreement stitches in the ECHR into the constitutional fabric in a way that makes it at least more difficult to get rid of, despite the very best efforts of some very powerful people and others to achieve that end. However, a lot of the human rights provisions of the Belfast Good Friday Agreement have been really neglected, like the All-Ireland Charter. Does anyone remember that? Bill of Rights for Northern Ireland? Practically no progress on that. Things like the human rights institutions, that's I suppose it's a mixed bag. And so the one, I suppose, enduring thing, which in a sense predates the Good Friday Agreement, but for the North has been the ECHR and the UK Human Rights Act. Different in the South, the ECHR Act actually is a weaker version of what you have. And in some of the models that were put forward last year, to replace the UK Human Rights Act, some of them were actually embarrassingly like the ECHR Act in the South, admittedly without the underpinning of the Irish Constitution. So I'm making that point, but I'm also, in as mature a way as possible, arguing that of course we have the written Constitution and those of course rights and unenumerated rights and all sorts of things. So I'm not, I don't want to make it as a cheap shot, but having said that, the weaker form of incorporation that we went for all sorts of, self-serving reasons, did raise its head in some of the models that were proposed last year, and I think that was somewhat embarrassing. How do you deal with this? I mean, fundamentally, the problem is, of course, Brexit. I mean, Brexit is a huge problem for people who identify as Irish and European in Northern Ireland, and it's an extremely painful thing, particularly when you consider that a majority of people in the North voted against it. It's also madness. I mean, it's complete madness from any kind of an economic point of view, and it's very self-defeating and the ultimate own goal to see what has ensued since. And, the transcendent fix, if there is to be one, is likely to arise, I suspect, in the context of reunification. I mean, that's now a live topic of discussion and debate. It's not going to happen tomorrow, but it's certainly being discussed today and tomorrow. And, it's no longer a theoretical or a fanciful discourse. And therefore, I think in that context, we have the opportunity. A huge credit should go to people like Professor Colin Harvey in Queen's, who has really led out on this and done so with great courage and conviction, that we really have to think seriously about human rights and equality in that context, and not, by the way, in the kind of add-on and tokenistic way that was done in the Belfast Agreement. Obviously, the Friday Belfast Agreement is an immensely valuable thing and a huge credit to everybody involved. But the human rights and equality bits were not, really serious human rights and equality bits in the sense in which they should be in any constitutional order and any constitutional system. And I think in that regard, looking forward to a context in which there may be reunification on the island of Ireland and that the states on the island of Ireland are reconstituted, instruments like the EU Charter of Fundamental Rights will become hugely important. The ECHR correctly will be seen as valuable but quaint. Like, it's not the be-all and end-all of human rights. Obviously, it's worth fighting for in the context in which you find yourself now in Northern Ireland as part of the United Kingdom. But going forward, it's not the be-all and end-all. It is hugely important, but there's an awful lot more to be gained, even if you view it as some kind of neutral or external benchmark, in framing the constitutional order based on rights and equality. There's an awful lot more to be gained by looking at the EU Charter, and that's where it's at. And I, just in that connection, in Galway, I used to teach a one-semester course on European human rights. It's now a year-long course, but it's not just a course on the ECHR. It's a thematic course.
Sure, yeah.
It's a system course based on the ECHR and the EU Charter of Fundamental Rights, because that's what I think will be the norm for teaching European human rights in the coming years. And difficult to manage all the material, even in 1 year long course, but it's much more valuable in terms of situating current discourse on rights and future prospects.
I remember doing the module many moons ago. Just, I suppose I'm very privileged here in this, that I can hold this space for both legal practitioners and academics and campaigners and legal activists, and can see, both sets of people can advocate for a particular matter through their work, albeit in very different ways. Whether it's through writing, publications, lobbying, advocacy, membership of boards and panels, again, very important. So I'm just interested in your perspective and your opinion on activism and the law. I mean, the name of the podcast is Activist Lawyer, and how, you know, the relationship between activism and the law. You know, I know you teach on it, but I suppose on a personal level, how can we make change through the law and therefore in society through also activism?
Yeah, I mean, if you go back to the basics of the public interest law approach, as discussed by people like Professor Jerry White in Trinity and others, and as practiced indeed by organisations like FLAC and the Public Interest Law Alliance in Dublin and many others, you know, throughout these jurisdictions, nobody would be so bold as to say you can achieve, you know, change only through an aspect of public interest law, like public interest litigation or whatever. And if you want to see, say, a model, a really good model of best practice and current best practice in that area, it's the Global Legal Action Network, or GLAN law, which is run by a number of people there. They actually have a base in Galway, Garrod O'Quinn and others, and Jerry Liston, others who have, I think, a really excellent approach to, you know, achieving change or advancing change through different forms of activism, different forms of coalition building, bringing different levels of expertise to things, whether it's kind of, you know, legal litigation type work or journalistic type work or web-based work, work that's very kind of impactful in terms of the public imagination, like the recent case taken by the Portuguese children in the European Court of Human Rights. Regardless of the outcome of that case, I think the actual visual impact of those children appearing in front of the court with their claim is inestimable. I think it's, you know, really, really valuable. So I think what works is to not see law or litigation as the be-all and end-all, to not see your particular expertise as the be-all and end-all. It's about, you know, effective coalition building, effective alliances with others, bearing in mind the value of what others bring to, you know, to coordinated efforts, and also seeing, I mean, without losing sight of any radical ideas that you may have, that sometimes change is incremental, and sometimes incrementalism as a tactic works without abandoning any aspiration towards a more radical or more profound change. And I think that's, you know, hugely important. I think, like I always used to say this in the past when I was working full-time in activism, that lawyers are useful. That's the best we can do in any setting, is to be useful. But you have to always remember they're useful to the other side as well. And therefore our utility, you know, has to be measured in that way. And there isn't kind of, you know, it strikes me as a real concern that I see this all the time with students, you know, that the big firms, and particularly now because there's full employment and everything, big firms really want, you know, the best students, and they want the best, most rounded students who have the best personalities and the best everything and all of that. And, you know, I'm very much of the view that, well, we should ask the best students what they want to do, and we should ask all students what they want to do. And sometimes, you know, you see kids, I see this all the time here in Galway, who would be really good barristers. You know, they'd love to be barristers. But, you know, the practicality of making it at the Irish Bar and the challenges facing practice at the Irish Bar now are so immense that, you know, if you really want to encourage that student to do the bar, you have to do so in a way that informs them of the challenges, but not so much as to turn them off doing what is a proper vocation. Sometimes you end up saying, well, go someplace like London, where you can be a pupil and where you can be paid and not have to wait for years and years to make some money at the Irish Bar, even though you're working very hard during that time. And those kinds of issues that really are, you know, they're wicked issues really that need to be sorted by the legal professions here in the South aren't really being addressed adequately. And there's a huge push in Ireland now for this thing called Ireland for Law, you know, which is to sell Ireland as a jurisdiction for dispute resolution. You know, the only jurisdiction in all of this kind of sales page. You know, you have it's very commercially driven. It's very much something that the big firms want. Want a lot of the judiciary are involved in it as well. And at the same time, to be fair, they're arguing for improved access to justice and things like that. But those messages might be mutually exclusive. They're not really compatible messages. And I wonder really what is the priority. And that troubles me quite a bit. You could take the view that something like Ireland for Law is an encouragement of forum shopping. And should that really be a priority, where the real priority should be to ensure that everyone has access to justice and that it's possible to have viable careers as practitioners within the system, and not close that off to people who don't have the financial wherewithal to make it without making a salary from it, things like that. And those are the kind of things that kind of bother me a bit about law within the broader kind of public interest piece. How will it survive in that setting where, the emphasis is on money making and shoring up systems that are intrinsically unfair and unjust? And that for me is a bother. But one that has to be chipped away at, I think.
Excellent. And just, I suppose this brings us back to our original discussion when we opened up. We're often asked by listeners, who are interested in working in human rights, interested in getting involved in public interest law. If someone is listening and contemplating entering into the world of law in general, what advice would you have for them if they were to pursue a career like yours, so in the academic world?
Well, if somebody wants to be an academic, when I accidentally became one, it was a very different career structure or career path to what it is now. There's absolutely no way I would, on the basis of which I had entered that career in the past, be able to do so now. So it has changed hugely. And one of the worries I think about academia is that we may be constricting the freedom of academics to comment and engage to the degree that they have done in the past. There's a huge emphasis now on, say, research funding, and there's a huge reward for research funding. By implication, there's a punishment for no research funding. And in disciplines like law, where funding can be achieved, maybe not to the extent that in certain STEM subjects or whatever, that can ultimately impoverish the benefits of academic freedom, in the sense that you can end up doing a lot of research that shores up the system or that informs the system in some kind of, comparative advisory way or whatever, but that doesn't actually challenge it, or that impedes your possibility of challenging it because of the obligations that go with research contracts and such things. That worries me a bit. Having said that, I don't think academics have ever used their academic freedom to the extent that they could to, challenge the system and such like. Challenges to the system, say through public intellectuals or whatever, have actually usually come from outside academia and not from within. They come from writers and playwrights and journalists and people like that, activists of one sort or another. So I'm not overclaiming the value of academic freedom for the noble history of academics, far from it, in fact. But I am worried that, the future orientation of academic careers will not be at all towards challenge and will be very much towards shoring up the system and adding value and things like that, not doing the fundamental things. The same arguments can be made against scientific research, but on our side of the house, I think that is worrying. And there are still amazing people who do all of that kind of work and manage within those strictures to do extraordinary, impactful work and radical work, and that's something to be really cherished. And I have to say, in my own place of work in the University of Galway, I always felt there was a freedom there. Maybe it was indifferent, I don't know, but I always felt that there was this kind of support for academics who engaged in the public square, maybe to the neglect of other things that they should be doing, but with impact. I always felt that was valued, in our university, and I hope that is something that continues. And certainly, the kinds of activities I've engaged in, I never felt a pressure not to do any of that. In fact, most of the time, I felt that was valued and celebrated. But I think in the future direction, I wouldn't be advising somebody young entering academia to do what I did. I certainly wouldn't do that. That would be bad advice. Would I say become an academic so that you can be a really effective activist? I'm not sure that I would. I think that you can do this kind of work in other spheres. You can also have hybrid careers where you're a part-time academic.
That's right, yeah.
And a part-time activist and that kind of idea. One of the things I do with my human rights students, and again, it's interesting because you said you were coming from Newry, I do talk to my human rights students about the late Professor Kevin Boyle, who was associated with Galway and was from Newry, because he, to me, is the model scholar activist. He is the model of the academic who engages both as a legal practitioner but also as an activist in the public square and transnationally. And one of the great, I think, legacies of someone like Kevin is that, his own work, his amazing work, speaks for itself, but the battalion of optimists that he inspired to do that work differently and better is really and truly an enduring legacy. And I think that's something that I feel inspires students. If you talk to them about, Kevin as somebody who was there long before they were born in Galway and went on to do the great things that he did in Essex and with Article 19, say nothing of the great things he did when he was a very young person in People's Democracy and things like that. Yeah. That when you talk to them about people like that, or when they meet activists who are out there doing what it is that they might do, that is much more effective than, preaching legal doctrine or ideology at them. And it makes it more, I think, relatable, more imaginable for them as something that might define how they live their lives. But to go back to the point I made at the very beginning, it's about planning, but not planning excessively.
Yeah, absolutely. Look, that's so insightful and so valuable. Professor Donncha O'Connell, I'd like to thank you for giving up your time today and for joining us here. We'll follow your work. There's so many points there that are going to be live over the next few months, and we'll also share the event that you mentioned as well. So thank you so much.
Thank you, Sarah.
Thanks everyone for joining me today. If you like the show, please remember to share and leave a review if you have a moment. And you can also check out our website, www.activistlawyer.com, where you will see some blog articles written by our guests and contributors, as well as some fabulous Activist Lawyer merchandise.
This podcast was recorded in Granite Podcast Studio. Interested in starting up your own podcast but don't know how? Granite Podcast Studio can help. Record your podcast in our state-of-the-art studio, which is based in the heart of Newry City. Our studio has cutting-edge and user-friendly technology and can seat up to 4 people. We also provide an editing service for our team, using your guidance and editing notes to provide you with a flawless finished product, leaving your listeners wanting more. For more information on how you can get started, visit www.granitepodcaststudio.com.